Okay, good afternoon, everyone. I'm Jennifer, a legal executive, and it is my pleasure to be the moderator for this webinar. On behalf of Ella Cheong firm, I'd like to extend a very warm welcome to each and every one of you for being here with us today.
My name is Liangshu, and I'm an IP executive with Ella Cheong LLC. So let's move on to my content for today. So I hope all of you can see my screen. So for my part of the presentation, I'll be talking first about worldwide patent filing trends. I'll be giving you a little bit more about what a patent is, the rights that a patent confers, and some examples of patents that have been granted. I will also be talking about some of the requirements, legal requirements in particular for obtaining a patent, and a bit about patent ownership, which is sometimes not very, how should I put it? It's an issue that is important, but it's not been, I think, stressed enough. And I would like to perhaps highlight some issues that may be relevant to a company that is potentially thinking about filing some patents. And last but not least, I'll be talking about patent applications and their timelines in Singapore. So, okay, this is what this is actually taken from the US Chamber of Commerce website, and it's basically a international IP index, but in particular patents. So what you can see here, this is an overall economic score, which actually means that the darker the blue, the higher the economic activity. So obviously, North America, United States, Western Europe, Australia, Japan, and South Korea are all darkest blue, which means they have the highest economic activity. I think Singapore, which I think is located, where is Singapore located? Somewhere here, would also be dark blue if it was even visible from this map. Unfortunately, Singapore being so small is not. So if you compare that to the number of patent filings, so this represents the number of patent filings, and the darker the blue, the more the patent, the quantity of patents that have been filed in these jurisdictions. So I think it is directly proportional. What you call it, the strongest economies have filed the most number of patents, with one exception actually. If you notice, China is actually light blue with respect to economic score, but when it comes to patents, they are actually on par, pretty much on par with the United States and other developed economies. I think despite China's reputation of being copycats or as a result of this reputation, I think the Chinese understand very more so than most other countries that the importance of obtaining patent protection. So to quantify this, what we have here is the number of patents filed in various jurisdictions in 2019. So as you can see, China is leading the way by far. So if you take the next 9 officers and you add them up together, it's only slightly more than the total number of filings in China itself. So I think there's this great emphasis in China about obtaining patent protection. So, okay, let's talk about what is a patent. A lot of you know patents as being something that protects your invention and prevents others from copying it. But what actually is perhaps the rationale behind this? Why do governments basically encouraging a monopoly when, generally speaking, such things are not very, we call it, looked upon favorably? So I think one of the reasons is actually to encourage innovation. And this is done so because a patent, once it's filed, and eventually, it will always eventually lead to the patent being published, which means the contents of the patent will actually be known to, will be known to everyone. What happens then is that, give me a moment, yes. Looking at this Venetian patent statute, I think it actually, basically, in this particular passage here, men of such kind, these men referring to inventors, would exert their minds, invent and make things which would be of no small utility and benefit to our state. So this is the actual reason behind it. Because of this, the fact that patents are actually published, the governments actually hope to encourage innovation by encouraging inventors to actually share their ideas and their knowledge with the public at large. And in doing so, the public at large can perhaps make improvements to this technology. And I think this is indeed the case, because if you look at 80% of published technical documents, they can be found in patents. So perhaps I think this objective has indeed been met. And once an idea is shared, an invention is shared, anyone can review it and perhaps make improvements to it. And in this way, it helps the progress of technology and what do you call it, and society as a whole. So it encourages innovation, promotes this disclosure, and incentivizes and rewards inventors for such a disclosure. So this rewards and incentives are contingent on disclosing the invention in such a way that allows your competitors to actually perform it. So in exchange for these rewards, you first need to uphold your part of the bargain. And your part of the bargain is by providing a clear and what do you call it, accurate disclosure. So if, for example, you file a patent and perhaps the patent is in relation to a process, you deliberately omit certain steps, which are actually critical to the, what do you call it, to the success of the invention. And in doing so, if your competitors try to follow your instructions in your patent and they are unable to replicate the what do you call it, and obtain the desired end product, then that is actually a problem, because in that case, you're actually teaching nothing in exchange for a monopoly. So what happens is that a patent can be revoked on the basis that it fails to disclose the subject matter in such a way that it enables your competitors or anyone else who has knowledge in the art to actually work the invention. So so your disclosure needs to be an enabling disclosure, and not just a half-hearted attempt at trying to disclose something. So a patent protects two things actually: a product or a process. So in the case of a process, it could be an industrial process, and the protection actually extends to products which are a direct result of this process, and it grants you exclusive rights in relation to either of these two. So this limited monopoly awarded is only provided that it discloses a new invention and it meets certain requirements, which we will talk about later on. So this limited monopoly, it's limited in the sense that it only lasts 20 years. And this is provided that you pay annual renewal fees for your patent once it has been granted, or in some cases, even before it's granted. But this monopoly, it is truly a monopoly in that it gives you the right to stop others from making, selling, offering to sell, importing, using, or keeping the invention. Basically, any form of commercial use of your patented technology is can be subject to prohibition if you seek to enforce your patent. One thing to note, and I think a lot of our clients, once you have a granted patent, they ask me this question: so can I? Does it mean that I can make my invention and make my product, for example, with the patented technology, and nobody can sue me for patent infringement? This is not true, because I think patents confer upon you negative rights in the sense that it allows you to exclude others from using your patented technology. This is unlike, for example, copyright, where copyright gives you the right to make copies. So in that way, if you make a copy, you cannot possibly be infringing anybody else. Let me give you an example to illustrate this. So yes, it does not give you the right to use the invention as claimed. So let's imagine that someone in someone's patent, basically he claims a table with 4 legs. So this is the earlier patent, and you actually, reviewing the patent, come up with so-called an improvement. So this improvement is in the form of a patent of a table with 4 legs, and you go and get a patent for it, and it's successfully granted. So if you, for example, were to make your product, which is a table with 4 legs, are you infringing this earlier patent? The answer is yes, because in order to make out the case of infringement, all you need to do is have a product or with what do you call it, that has these elements in it. So you have a table and it does have 4 legs. This is a claim for a table with 4 legs. So you're necessarily infringing the earlier patent. So this is what I mean by it doesn't give you the right to freely use your invention, because one or more components of your table with 4 wheels, for example, may be subject to patent protection. It could in fact be the wheel, the mechanism that is subject to patent protection as well. So food for thought. Does this kind of table infringe either patent? The answer is it's not clear, because is this a table with 4 legs? I mean, one can argue that it's actually 1 leg, right? But it's possible that you can actually regard under the wheels and the structure above it to be a leg as well. So I think this is why doing in patent infringement cases, this is why you pay your lawyers tons of money to help you argue your case. So what can you get out of a patent? I think the first thing and the most apparent is that you'll be able to, once the patent is granted, you'll be able to take action against infringers. So when I mean take action against them, what can you actually get out of what we call it, of suing a competitor for patent infringement? So I think that it is basically a damage and account of profits. So either one of these, and so basically it is unlike for perhaps like in the United States, where willful patent infringement can lead to the what you call it, to the patent owner being awarded up to 3 times the evaluated amount in damages. So in this case, it is potentially profitable to sue someone for patent infringement in the US. But this is not the case in Singapore. I think the law is such that it is designed to put you into a position before the infringing activities occur and not reward you for suing someone for patent infringement. So damages and account of profits are a bit different, and you can only pick one depending on the situation. So in the case of damages simply means this. For example, you have been selling your patented technology, and you have been, sales have been pretty good until you notice that infringing products have entered the market and your sales have dropped 50%. In that case, you can be awarded damages for this loss of your 50% in revenue. But on the other hand, for example, if perhaps you have actually filed your patent not only in Singapore, but maybe in the United States, for example, or maybe in Europe, for example, and an account of profits, and you actually haven't really started marketing your product in the particular jurisdiction, assuming that this jurisdiction, the laws are similar to Singapore. So what happens is that you can actually ask for account of profits, because it could be the case where you have not started selling your product, so you don't have there's no real damage to you. But what you can do is get an account of profits from how much the infringer has made. So it really depends on the situation. In addition to a monetary award for damages or account of profits, you can also restrain the infringer from further infringing activities by way of an injunction, and you can also request for delivery up and destruction of his entire inventory of infringing goods. So I think it's quite beneficial, and it is quite effective in stopping infringers from preventing you from enjoying your monopoly. But I think to sue someone for patent infringement, you actually need quite a large budget. So this option may not be available to smaller companies. So another way that a patent can be used is as a bargaining chip, or as bargaining chips. So this is more from a large corporation point of view. For example, you're talking about companies with dozens or maybe even hundreds of patents. So if you imagine yourself being a large company with hundreds of patents, and your competitor having hundreds of patents, there's a potential that you may be infringing it may be the case that your competitor is actually infringing some of your patents, but the reverse is also true, in that both of you may be infringing each other's patents. So in this case, it kind of gives you pause, and also gives your competitor pause as to whether he wants to sue you, because you're simply going to sue him back. So in this case, it actually may prevent an infringement suit, and instead what happens is that both parties sit down and perhaps negotiate some sort of cross-licensing agreement. So in this way, your patent portfolio acts as a shield. It makes others think twice about suing you because you can do the same to them. So this is, sorry, I think I skipped a slide. Yes. So then another thing that you can hope to get out of a patent is to attract investment. And this is more relevant to smaller companies, startups, for example. So especially if your business is at its core technology centric, I think if you were to approach an investors, the first thing they are going to ask you is, do you have patents that protect your proprietary technology? So if you do, then the chance of getting investment is that much higher. So another attractive option for patents is licensing revenue. For example, you have filed your patent in 10 different countries. Perhaps of these 10 different countries, you have only managed to, you have only started to market it in 5 of these countries. So for the rest of the 5 countries, if you have no intention of actually expanding so fast, you could actually potentially license the technology to an interested local party and collect licensing revenue, which is actually quite a, it allows you to generate revenue at the same time as, while actually doing nothing. So hopefully it allows you to take nice vacations in exotic locations, such as the Maldives. So let me give you some examples of patents. This patent, dated 1930, is entitled Method and Apparatus for Controlling Electrical Currents. And I think some of you may have an idea what this is, because this is actually a patent for a transistor. And as I think some of you know, transistor is actually a building block of our modern lives. Anything electronic has a transistor in it. So this patent is entitled Navigational System Using Satellites and Passive Ranging Techniques. I think a lot of you can guess what this is. This is actually GPS. And it was patented in 1974, which I think is way before the... So if a patent is about the lifespan of about 20 years, and this was granted in, I think, 1974, probably was valid till protection was valid till about 1990s. So I think shortly after that, I think you would see a mass adoption of, what do you call it, GPS technologies in everyday appliances such as your mobile phones. So this is a more recent example of groundbreaking patent. So this patent is entitled CRISPR-Cas systems, methods of altering expression of gene products. This is a very important patent in the field of biotechnology because it allows targeted genetic modifications to be made, and this was previously not possible. And yeah, I think it's one of the most commercially valuable patents that have been filed in the last 20 years. But having said that, patents do not have to be about real serious stuff. So this patent is entitled Flatulence Deodorizer. It appears to be some sort of a pad which you affix to your bottom, and presumably it would absorb smells made from that you could be potentially emitting from your rear end. And this was actually granted a patent. So although perhaps this is not the most, has seen the most commercial success, it still nevertheless, it was awarded a patent on the basis that it has met the relevant legal requirements. So inventions, some of our clients come to us and they say, oh, my invention is really very simple. Can I get a patent for it? The answer is yes, actually. One of my clients actually came to me with a very simple water dispensing mechanism. And it turns out that when I had a look at it, I thought there's no way that this can be patentable. But in fact, it actually is. So you only put it together with like $3 worth of parts. And that is actually a patentable invention. So it doesn't matter how simple it is, but rather if it meets the necessary requirements. So should you patent your idea? In many instances, the answer is yes, but there are also instances where the answer is no. So let me go over a few examples of these. First question is your invention readily discernible? So if, for example, if you're selling a commercial product, right, and the consumer product, so anyone who gets a hold of it can, if they can disassemble it and reverse engineer it, then I think it's a very good idea to perhaps consider obtaining patent protection, because there is perfectly fine to reverse engineer. So one situation where you should not file a patent is if your patented technology is actually easy to design around. If someone reading can devise alternative solutions, which cannot readily be protected in a single patent application, or perhaps even multiple patent applications, then it may not be such a good idea to pursue patent protection. Of course, there are other instances where it may not be in your best interests to pursue patent protection. For example, if your competitive advantage or invention lies in a process which is performed in your factories or your plants, and this is not readily discernible because all you're selling is the product, right? And if you want to protect this process itself, is not readily discernible by the public at large. It's not as if you're going to give your guests a tour of your facilities and explain to them in depth what's going on. So in this instance, it may be better to protect your invention as a trade secret. So protecting it as confidential information rather than applying for a patent whereby it eventually will be disclosed to the public at large. So another thing to note is patents are actually awarded to the first inventor to file the patent. So what this means is that, for example, you have come up with this new technology. Perhaps let's use the example of the process, the inventive process that will be performed in a plant. And if one thing that may happen is that if you do not file a patent, someone else will. So when someone else files a patent, he will be awarded the patent, and not you. So in the past, in the US, there was this thing called first to invent, whereby if someone files a patent for a certain invention, if you actually devised the invention earlier and you can submit proof of you having done so, you will actually be awarded the patent instead of the person who filed it. So this is no longer the case. In US has now moved to be in line with the rest of the world, where it is on a first to file basis. So on that note, it may be worth considering filing a patent if you feel that your invention is in a field where there's a lot of research going on and where someone may actually be hot on your heels in terms of innovation. So let's explore some of the legal requirements for obtaining a patent. So these are the 3 requirements that have to be met. And basically, a patent has to be new, it has to be inventive, it has to be useful. So the technical terms for it are actually novelty, inventive step, and capable of industrial application. So of these 2, novelty and inventive step, what happens is that when a patent is filed, it eventually is examined. And what happens is that an examiner will try, in relation to novelty and inventive step, try to look for technology invention disclosures which are published before your filing date. And in doing so, what you'll do is do a comparison and try to discern if your invention is sufficiently different from what is already known. So I think this is the reason why an early filing date is actually quite useful, because the earlier you file, the less subject matter that can be used against your application during the examination process. So let's talk about novelty in greater detail. So an invention is novel if no single document discloses all of the claim features. So in a patent specification, there's a section known as the claims. Basically, it defines the scope of protection and the invention that you want to protect. So let's give you an example of this. So imagine if there's a prior document that describes a hairdryer with features 1, 2, and 3. And in your claim, you have features 1, 2, and 3. So if this is the case, your patent claims are not novel over prior document A. So how can this be cured? How can this objection be removed? So the first thing is that you can add additional features into your claim. Or another way of doing it is to have features which are different. They may function the same, but the way the function is fundamentally different. In each of these two scenarios, sufficient. These changes are sufficient to make your patent claims novel over prior documents. So it's actually relatively easy to overcome novelty objections. It's not so difficult to overcome inventive step objections. So invention involves an inventive step if the differences between the claim invention and the prior are not obvious. So, okay, let me give you this example here. So the prior, let's go back to the table example. So you have a prior document describing a table with a rectangular top and 4 legs. So you come up with an invention when you have a circular top with 4 legs. So the only difference is actually the shape of the tabletop, circular versus rectangular. So although your claims are novel over the prior document, the examiner is nevertheless going to say that, hey, the difference between a circular top and a rectangular top is immaterial. And that being immaterial, we are not going to allow your patent because it is obvious in view of this earlier document. Likewise, in the case of, like if we were to add features into your table, even, for example, if both tables are rectangular top, you add perhaps, I don't know, perhaps you add wheels to your table. So the difference then would only be the wheels, and then the examiner is up to the examiner to determine to what you call it, make a decision whether the addition of wheels is sufficiently different from the table as disclosed in the prior documents. And if he's of the opinion that yes, it is, then an inventive step is said to have been met. At least the requirement for inventive step is said to have been met. So lastly, industrial applicability is not something that is really, how should I put it, a big deal in terms of patent examination, because as long as it can be, an invention is said to be industrially applicable if it can be made or used in any kind of industry. So this requirement is very low threshold and is generally very easy to meet. So as long as the invention is of a technical character. Yeah. So let me talk about patent ownership. So if by default, the person who is the inventor of the subject matter in a patent application is the default owner. So if you have an inventor Eddie, and on the patent application itself, it will indicate the inventor and the owner. So it is necessary to include all your inventors in your patent application. You need to indicate who are the people responsible. So when I mean inventor, I mean the people who have contributed to the inventive concept of the patent. So what this is actually the difference between your patent and prior documents that is not obvious. That's what we mean. In other words, is the inventive concept. So oftentimes there shouldn't be too many inventors. Otherwise, it is very difficult to imagine that what do you call it? A single difference can be what you call it, concocted by 5 or 6 people. It's very how should I put it? It's very unlikely. So I think it's very important that you actually identify who are actual inventors as opposed to people who just were blindly contributing in terms of legs and muscles rather than in terms of inventive input. Yes, so an inventor can actually assign his rights to another person, and this person can be either another person or a company. And this is actually the ideal scenario if you're hoping to if you're hoping to attract investment. Because I think if, for example, your inventor is Eddie and you're the managing, and perhaps Eddie is the managing director of a company, but the owner of the patent is Eddie himself, I think investors will not feel confident to invest for the simple reason that if Eddie were to cut ties with the company, I think they will be left high and dry because the patent rights lie with Eddie and not the company. So investors like to see that the patents are actually under the name of the company that they are going to invest in rather than the individual, like for example, the managing director of the company. So let's talk a bit about employee inventions. Yes, in Singapore, I think it's quite favorable to the situation is quite favorable to the employer in that if you hire someone in the capacity of a researcher, for example, um, let me give you an example here. So let's assume that Michael is employee of a company X. By default, the rights to the patent lie with the company and not with Michael. And what are these conditions? Let me give you an example to illustrate this. So let's assume Michael is hired as a researcher, and his invention is a result of his research with company X. So I hired you as a researcher, and there's a reasonable expectation that in your research on behalf of the company, a patent can some invention can come out of it. So, however, Michael actually discussed problems with Paula, who is an employee of the company but works in the finance department, and she contributed substantially. Let's for the sake of example, say she contributed 50% to the invention during her free time. So the question now, right, is who exactly owns the rights to the patent? So let me give you the answer right now. So the actual answer is company X and Paula. So how does this come about? So company X derives rights from Michael because he's a researcher, and by way of employment, the rights to the patent lie with the company rather than Michael, the researcher. But Paula was not hired in the capacity of the researcher, and neither was she specifically assigned this research duty. In that case, half of the invention, half of the patent actually belongs to Paula. And this situation is, as you may, I think it's very undesirable for company X. But of course, this example is not what actually is perhaps happens in real life so much. But what I'm trying to illustrate is this. If you fail to identify all your, and I think this is another issue that is quite relevant in the sense that, you see, in this case, if company X were to go and file the patent application, and Paula later on learns about the existence of the patent application, she can actually make representations to the patent office and say that, hey, actually, I am an inventor, and Paula being an inventor has a right to the invention as well. And this can occur anytime while the patent is during the patent application stage, and even after the patent has been granted. And I think this is this undesirable outcome for company X. But the more relevant, I think the more relevant example is, for example, if you're a company and you have contractors, and sometimes it is the inventors and the contractor that is at least in part an inventor. And that's where you can have potential issues, especially if you from the onset do not identify your contractors as being inventors. There can be these kind of potential ramifications down the road. I think and so one should be quite particularly careful about this to avoid any issues with patent ownership down the road. So let me talk a bit about the general timeline for filing a patent in Singapore. I think a lot of our clients are very interested to know this. So when you file after an patent application has been drafted, which typically takes about 5 weeks, you can file your application in Singapore, for example. In Singapore, if you choose to file your application, you actually have 36 months by which to file such an examination. So if you wish to speed up your patent application process, you can file a request for examination somewhere close to day 0, as opposed to closer to the 36-month deadline. So all in all, what happens during the examination process is that the examiner will do a search, he'll find prior art, he will assess your claims in relation to novelty, inventive step, and some other requirements. And if he's happy with it, your application will be granted. So this process here, although I've indicated for 8 months, this is assuming that you filed your request for examination rather late. So the process actually can be shortened to approximately 2 years to 2.5 years. And thereafter, if you want to maintain your application, you have to pay a renewal fee from the 5th year onwards, and yearly all the way up to the 20th year, assuming that you're interested in maintaining patent protection for the entirety of the 20 years.